Imagine stepping into a majestic Baroque theater. The lights dim, and suddenly an innovative electronic melody bursts onto the scene. This is AI serendipity, the harmonious meeting of the most exquisite tradition and the boldest avant-garde. Welcome back to AI serendipity, where law meets innovation, and we always ask the hard questions. I am Santiago Martin Caravaca, an Italian-Spanish dual-qualified tech and IP lawyer, a technologist by curiosity, and your guide to the twists and turns of the Suno AI case. Today, we are peeling back the layers of a legal chessboard where every move redefines copyright law. Here's the question of the day. Should the legal chessboard focus on the queen or play the entire game? Pour yourself a single malt, settle in, and let's begin. Picture this as the opening of a chess match. The plaintiffs, major record labels, are seasoned players, armed with decades of legal precedent, economic clout, and unrelenting desire to protect their domain. Their opening move, a meticulous, almost theatrical complaint, heavy with phrases like pervasive illegal copying and willful infringement. These aren't just allegations. They are designed to set the tone, painting Suno not as an innovator, but as a calculated rule breaker, trampling both legal boundaries and moral decency. Repeated over and over, they drum a single idea into the narrative. Suno didn't just cross the line, they sprinted over it, waving a flag that says, "We knew what we were doing." The plaintiffs aren't playing the whole board. They trained their sides just on the queen. For them, the queen is Suno's training process, the foundation of their AI model. They argue that this foundational act of copying, allegedly built on tens of millions of copyrighted recordings, is itself the infringement. Their strategy, the real strategy, lies in their focus on how Suno learned to create, not on what it now generates. The plaintiffs shift the spotlight from Suno's output to its inputs by sidestepping the nuanced debate of fair use for outputs. They aim to fight on clearer legal ground. In essence, they are saying, take the queen and the game collapses. But Suno isn't backing down. Their response is calculated, almost minimalist. They concede, yes, our artificial intelligence uses data. It is no secret that the tens of millions of recordings that Suno's model was trained on presumably included recordings whose rights are owned by the plaintiffs in this case. But they reframe the question, is it transformative? They invoke landmark cases like Google versus Oracle, subtly positioning themselves as the underdog innovator facing an outdated legal framework. Plaintiffs are not presently alleging that these outputs themselves infringe the copyrighted recordings unless court discovery reveals that they directly or indirectly recapture portions of the copyrighted recordings. And here's the response of Suno's defense. They call this a concession. Suno's legal team is essentially saying, fine, you don't like how we train our model, but your refusal to claim our outputs are infringing is your Achilles heel. Why? Because it shifts the focus away from what the AI generates and onto the process itself. Now, to rewind for a moment and set the stage. In their complaint, the plaintiffs recount an incident involving Suno's AI and the iconic lyrics to Johnny B. Good. They allege that by prompting Suno with those lyrics, they demonstrated the model's ability to generate outputs that could infringe on copyright works. But here is where it gets complicated. The plaintiffs stop short of accusing Suno's output of direct infringement for now. Instead, they pivot to the broader claim that Suno's model was trained on copyrighted recordings without authorization. This creates a suspenseful air of a mystery, a classic whodunit in the legal sense, meant to heighten the stakes of discovery and potentially unearth smoking gun evidence. Suno, however, refuses to play into this narrative. When they respond with, "This isn't a whodunit," they are dismantling the plaintiff's strategy in one stroke. They are playing the long game. Suno essentially says, yes, we use data at scale. Now, let's talk about whether that's legal. It is a bold move that forces the plaintiffs onto a narrower battlefield. This strategy does two things. First, it undermines the plaintiff's ability to build suspense around what might emerge in discovery. Second, it forces the conversation to center on Suno's key defense. The argument that training an AI model, even on copyrighted works, is transformative and permissible under the law. Their reasoning, it is not about the initial copying itself, but how that copying serves as a larger purpose. Suno argues with precision that under US copyright law, making a temporary backend copy of a protected work as a part of a technological process is entirely permissible, as long as the ultimate output is transformative and not infringing. And they don't stop there. They invoke the heavyweights of copyright jurisprudence. Their message is very, very, very clear. Every time the question has been raised, whether it is books, images, software, or even student papers used for plagiarism detection, the courts have sided with innovation. By invoking these landmark cases, Suno subtly positioned itself as the underdog innovator facing an outdated legal framework that struggles to keep up with the pace of technological progress. Suno's transparency isn't just defensive, it is strategic. By admitting to scale but framing the issue as a question of precedent, they challenge the plaintiffs to prove that AI training is fundamentally different from other historical uses of copyrighted works. Suno leans into ambiguity while preserving the evidence. They even invite discovery, knowing that the scale of their dataset make it nearly impossible for the plaintiffs to definitively trace every copied element. By steering the debate away from a whodunit and towards a broader discussion of legality, Suno reframes the conflict on their terms. It is a daring tactic, one that turns a potential liability into a strategic advantage. Whether the courts will agree remains to be seen, but one thing is clear. Suno's response isn't just a defense. It is a move to resave the rules of the game entirely. But here's where the drama intensifies. Deep within the complaint, the plaintiffs reveal what they claim is a startling admission from one of Suno's early investors. Honestly, if we had deals with labels when this company got started, I probably wouldn't have invested in it. I think they needed to make this product without the constraints. Constraints, one word, loaded with a lot of meaning. And what are those constraints. The plaintiffs argue they are referring to copyright laws, the rules that require creators to seek permission before using protected works. The plaintiffs go further, alleging that Suno's investors and leadership knew the legal risks from the start. Another excerpt from the complaint claims, "This was the risk we had to underwrite when we invested in the company." It's a bold move by the plaintiffs, transforming this case from a technical copyright dispute into a moral indictment. The narrative they weave is clear. Suno wasn't just innovating. It was gambling, knowingly flouting the rules to get ahead. But is it enough? That is the question the court and perhaps the jury will need to answer. Now, let's dissect the plaintiff's push for bifurcation, the request to split the case into phases, with fair use tackled first. On the surface, this seems efficient. Resolve the core issue and the rest of the case could fall away. However, there is a subtle risk here. By emphasizing fair use as the threshold issue, the plaintiffs inadvertently acknowledge its centrality to the case. If the court grants bifurcation, the focus narrows to fair use, potentially fast-tracking a resolution. But Suno argues that bifurcation artificially separates interconnected issues such as licenses practices that are relevant to both fair use and damages. The plaintiffs want to control the pace and framing of the case, while Suno seeks to broaden the debate, forcing a more holistic examination of AI, creativity, and copyright. From a strategic perspective, bifurcation could favor the plaintiffs. A ruling against fair use early on would cripple Suno's defense, but Suno's resistance suggests they are confident in the complexity of their arguments, and they want the jury to see the full picture, not a curated slice. Their primary argument hinges on transformation. Suno asserts a tool that empowers users to create music rather than replicate it. Suno's language is precise, almost surgical. Our tool creates a non-infringing new product. The process is a back-end technological framework invisible to the public. The implication, this isn't about mimicry, it is about innovation. By positioning themselves as responsible innovators, they seek to dismantle the plaintiff's narrative of moral wrongdoing. But Suno doesn't stop at fair use. They employ what I like to call the kitchen sink defense, a slew of additional arguments designed to complicate the plaintiff's case. For instance, copyright misuse. Suno accuses the plaintiffs of leveraging copyright as a weapon to stifle competition, a bold counterattack that reframes the lawsuit as a monopolistic power play. Here's where Suno's strategy truly shines. They are reframing the lawsuit. It is not just about copyright. It is also about competition. Suno alleges that the plaintiffs are weaponizing copyright law to stifle innovation and maintain their dominance in the music industry. And this is a masterstroke, because if Suno can convince the court or the jury that the plaintiff's actions are less about protecting artists and more about monopolistic control, it could shift the balance of sympathy. The plaintiffs rely heavily on tests of Suno's outputs, claiming they saw clear similarities to their copyrighted works. But Suno's counter is equally clever. They admit to using a vast dataset but avoid specifics, pointing out that their model generates entirely new outputs through a process they describe as transformative learning. It is like saying, yes, we learn from the greats, but what we created is something entirely our own. What makes this case fascinating isn't just the legal arguments. It is the broader stakes. The plaintiffs are asking the court to set a precedent that training an AI model using copyrighted works, even without producing infringing outputs, constitutes infringement. On the other side, Suno argues for a different future, one where data used to train AI is seen as transformative, unpermissible, under fair use. They frame this case not just as a legal battle, but as a fight for the soul of innovation. Thank you for joining me today on AI Serendipity. If this episode sparked your curiosity or left you questioning, don't just listen, subscribe. Join us here at AI Serendipity. In our next episode, we'll explore how the plaintiff and the defendant in the Suno AI lawsuit faced the challenge of the blank page, crafting opening paragraphs that not only frame their arguments, but set the stage for everything that follows. Until then, keep questioning, keep asking the hard questions, and remember, innovation is inevitable, but how we embrace it defines who we are. See you next time.